So thank you all very much indeed for joining us. Today we're going to be talking about social media and reputation management. This is the second in our webinar series, following the earlier session on London Midland's perspective on how they as a train operating company have used social media to help manage their reputation. But today we're looking very specifically at the legal implications of social media. And because of that, I am joined today by Magnus Boyd, a lawyer from Hill Dickinson. Welcome, Magnus.
Good afternoon. Thank you.
And Magnus, just give us a couple of minutes on your background and area of expertise, please.
Well, I'm a defamation and privacy lawyer, which in practical terms mean I deal in crisis management or the legal aspects of crisis management, and that means most of my time is spent in collaboration with public relations advisors, as they're known in terms, and managing uh, managing a crisis as it hits.
Excellent. Thanks, Magnus. So today we're going to be covering the following areas. First of all, just setting out the context for this new landscape that both us as communicators and also the lawyers are facing, looking specifically at some of the recent legal developments, how to manage third-party comments, so other people talking about us, how to keep ourselves safe when we are communicating officially on behalf of our organisation, how to manage maybe less planned communication by our employees online, and how the lawyers and the communicators can work together in perfect harmony, as we know that we do all of the time. Isn't that right, Magnus?
Absolutely.
Okay, and there will be time for questions. If you can post any questions via the chat mechanism, that there's a pane on your screen, hopefully, that you can post any questions. We will attempt to deal with as many of those as possible at the end of the session. We will be finished by 2 o'clock, and you will be able to get a copy of this presentation alongside a more detailed report following this session. So I don't think it's a surprise to any of us that we are dealing with a new landscape, one that has been created by the rapid rise of social media. This is a piece of research conducted by one of Magnus's competitors, Freshfield, but we both agreed this was actually quite a nice way of demonstrating the context that we're now dealing with, in that they found that 28% of crises these days spread internationally within 1 hour, and that within 24 hours, 69% of crises had spread internationally, on average reaching 11 countries. So the speed and spread of crisis is far greater than ever before. However, what Freshfields also found was that it took organisations an average of 21 hours to respond. So you can see that many organisations are behind the game when managing crises in this new digital age. And that's really the context that we're operating in. And so we need to work out how can we effectively protect reputation in this new digital age. Now, I'll be chipping in with some views on what we can do from a communication point of view, but firstly, Magnus, what's changed? How has the law had to adapt to this new situation?
Well, the first thing we should say, perhaps, is that the legal principles underlining this area have stayed the same. So, but what the courts have had to do is to adapt the application of those principles to this new climate. And obviously, the principal concern is, as the Freshfields report highlighted so acutely, is the speed of dissemination. Um, that is that, as the statistics show, can be phenomenal and phenomenally damaging. But it's only been relatively recent that the courts have actually acknowledged that, and there was this case was actually the first libel trial in this country over a tweet, and it was between Cairns and Modi. Cairns, the New Zealand ex-cricketer Modi, the organizer of or one of the founders of the Indian Premier League. Although the libel trial took place in this jurisdiction. And in the judgment of that case, that the judge took the opportunity to draw attention to the speed of dissemination problem, what he called the percolation phenomenon. And as we've got on the screen, we've got the bit of the judgment that I think is of most interest, but in particular the last line where the judge said, in our judgment, this percolation phenomenon is a legitimate factor to be taken into account in the assessment of damages.
So in other words, that means that damages could be higher.
Much higher.
Yeah.
If the court understood that there was it was reasonably foreseeable that these allegations would go viral, as it were. Now, how that's all very well after the event, but how does one use that pre-event in respect of crisis management? Well, it's useful because, in a sense, it's a stick that we can now use to beat the potential publisher with, and we can say prior to publication or broadcast, in respect of a tweet or a social, anything that's published via social media, if you intend to publish this allegation, it is reasonably foreseeable to us, as it must be to you, of the risk and likelihood of this going viral. That would sound in damages if we were to sue after the event, and in the event of any such litigation, a copy of this letter would be made available to the court at the appropriate time, and we would invite the inference of the court that that was your intention. And then, so we're not simply dealing with general damages there, we're dealing with a sort of an aggravated damages claim, which can be 4 to 5 times higher. So it's a very real stick.
Excellent. So we'll come on to later on in this webinar how we can try and keep our organisations either safe from harm, or how we can take action against those who are seeking to harm us. But first of all, just a few communication comments with regard to the speed of dissemination. What can we do as organisations to deal with this dynamic? Well, first thing I think we would say is reconduct your scenario planning, because if you did a reputational risk assessment 5 years ago and haven't updated it, you very much need to do so, because this speed and spread that we've seen means that crises are both more likely, because the world is so much more transparent because of social media, and the impact of those crises are so much greater due to the percolation effect that Magnus referred to. Secondly, it's critical to develop your capacity to respond before the crisis happens. This speed that we saw in that earlier graphic means that you clearly won't have time to put things in place after the event, and so creating the resources and the people ready and able to respond beforehand is even more important than ever. But all of that said, and I'm sure this is something that lawyers would heartily applaud, I think despite this speed of dissemination, what that doesn't mean is that communicators should be communicating without being sure of their facts. We've always said that speed is a desirable attribute of effective crisis communication, but accuracy is an essential attribute. So quick, yes, but right, accurate, always. So that was speed of dissemination. There's another dynamic that the law has had to deal with, Magnus, and that's anonymity.
That's right. The ability to post material anonymously is an increasing bugbear. I sound like an incredibly pompous lawyer when I say this, but with rights come responsibilities, and that is being ignored. Now, again, what the courts have had to do to respond to this is acknowledge the problem, which they've been quick to do, and in addition to that, we as lawyers are now increasingly being instructed in respect of the investigation of the source of an anonymous blog or post. And often that will involve applying for what we call a Norwich Pharmacal application, or a Norwich Pharmacal order. And these orders one obviously needs to present appropriate evidence to the court, and that sort of evidence will be evidence of the damage that is being done as a result of the offending publication, and the difficulties that one is having in isolating or establishing who the offending author is without the assistance of the court. And at that, if the evidence is sufficient, the court is or the courts are increasingly happy to grant orders that enable you to obtain the whatever relevant information you may require from, for example, a telecommunications company or that sort of thing. And again, we've got a reference to a judgment from a fairly old now, about 10 years old, the Motley Fool case. But again, this was the start of the process, and now courts are increasingly familiar with it. And there the judge said, I have no hesitation in finding that the balance weighs heavily in favour of granting the relief sought to find, otherwise would be to give the clearest indication to those who wish to defame that they can do so with impunity behind the screen of anonymity, made possible by the use of websites. That the courts won't. The courts are effectively saying we won't let them get away with that.
Quite right too. Okay, so that sets the context for this new landscape. So let's move on to some specific recent legal developments and what those mean, or what those could mean for your organisations. And I guess the first area to cover is that limitation period and the Defamation Act, Magnus.
That's right. I mean, there's been a lot of this area of the law has been in the news a lot over the last 3 or 4 years, with phone hacking, with Leveson, etc. But by far the most significant development for us in terms of crisis management is the 2013 Defamation Act, which actually came into force on the 1st of January this year. So it's very new. Now that in turn gives rise to an issue at the moment, in that a lot of the statute, we don't actually yet know how the courts are going to interpret that. We haven't had in the 7 months that we've had or so, we haven't had that many interlocutory applications or any of those sorts of opportunities for the courts to offer guidance. So we're in the dark. It's relatively unpredictable, and frankly, that makes it all the more important for lawyers to be working collaboratively with PROs in this area.
Yeah.
But we've essentially, there are sort of 4, I think, of the most significant developments have come out of this, and one of those is that the limitation period for online publications has now been brought into line with the existing law, which related to hard copy publications, which was a limitation period of 1 year. So it used to be that if an article was published in the Times over a year ago, you couldn't sue. But you could sue on the online publication of that article, because the law effectively took the view that online publication was ongoing. So every time you clicked and accessed that article, that gave rise to a new publication, a new cause of action, a new limitation period for a year, and obviously newspapers and magazines, that's impossible for them to cope with. Suddenly their archives are completely exposed to liability. So this now brings both the online world and the hard copy world, if you like, into line with each other, and there's a 1 year limitation period for both. Now, the significance for us is that one needs to be monitoring all the time what is out there, because you no longer have the luxury of suing on something that you discovered online from however many years ago. So that's the first development. The second relates to the process by which we try to get material removed, or offending material removed from posts and blogs and any other online platforms. Now, this really comes down to who is liable for a publication online, and there can be numerous parties. So obviously the first person in the headlines is going to be the author.
Yeah.
They may be anonymous, they may be difficult to track down, they may be in a different jurisdiction. So there are always issues around each of the possible people to sue. The second person in the process, who is equally responsible for the process of publication, will be the platform.
Yes.
The website, the blog, the post, whatever it might be. They too will be equally liable for publication.
Right.
The third potential party that is liable is the internet service provider. Now, and then the fourth is in effect the search engine. Now, the law has gone backwards and forwards, sort of flip-flopped as to where they really think liability, whether search engines are liable or not. And the most recent judgment is, again, it's a few years ago now, but the court is increasingly taking the view that search engines are so robotic or so automated that in effect they shouldn't have liability. So we've now got to look at the three: the internet service provider, the platform, and the author. Those are the people who are liable. But the Act has provided, there is the Act, and then under the Act, if you like, is a new regulation. And that regulation provides a sort of step-by-step process by which people can write to one of these platforms in the event that you don't know who the author is. So the expectation under the Act is that the author is should be primarily responsible. And if you want something removed, you should be writing to the author in the first instance. If you can't establish or identify the author, or they're writing anonymously, this is a new procedure whereby you can write to the platform. And the most useful thing, again for our purposes, is that it provides a very tight time scale for a response. So one of the issues that one would have with, say, Facebook or Twitter is you would write a letter of complaint, but the delay, partly through scale and things like that, meant sometimes it can take weeks for offending material to be removed. Now they're under an obligation to be removing this, or to at least be responding to you within 48 hours, and then responding within 7 days.
And what's the definition of author? So I'm thinking about the online version of a newspaper. So an article has said something that we believe is defamatory about our organisation. Is the author the publication, the actual person that wrote the article? Who is the author defined as?
The author will be multiple.
Yeah.
It will be the journalist. It will be the editor.
Yeah.
And then it'll be the publisher of that newspaper. Now, broadly speaking, if you look at libel judgments, you will see they're often against MGN Newspapers Limited or associated newspapers. Why have we gone after the publisher as opposed to the editor or the journalist? Because they've got the deepest pockets.
Yes. Okay. So just a quick reiteration of what Magnus said earlier on. Critical to taking advantage of these legal remedies is knowing that something defamatory has been said about you. So I just further endorse the necessity for effective online monitoring if we're even to have a chance of using these remedies. So, okay, there's the first couple of recent legal developments. What else, Magnus?
The third is the most recent, which is the right to be forgotten, and that's been sort of heavily publicised. It emanated out of the European Court of Justice decision against Google of about a month ago. Now, what wasn't reported was that actually that judgment wasn't really saying anything new. It was an articulation of the existing law, and more importantly, it's been, or the decision was drafted in line with a data protection regulation that is going to be coming down the track in the next 18 months or so. And the repercussions of this are that it enables individuals rather than organisations, I should say, to write to a search engine, and this does apply to a search engine as opposed to the offending website or blog or post particularly. So you would write to the search engine in the event that the material is irrelevant, out of date, or inappropriate, inaccurate, in other words. And so this has given us a new right. Now, the Google, unsurprisingly, has been inundated with such requests. It has tried to automate the process. So there is now an online form. It's interesting that the online form is very restrictive in what you can say, or in the reasons you can cite in order to have this material removed. And from a legal perspective, what I would say is, by all means, complete the form, but don't be afraid to have some sort of accompanying note explaining in more detail the precise basis of the irrelevancy or the inaccuracy. Now, it's important to remember that the basis of the law around this is it's around inaccuracy. It's not, you can't get something removed because you don't like it. It's got to be inaccurate, misleading, distorted, false in some way. But if it is, then Google now, under this judgment, has to look at it and has to form a judgment. And the judgment effectively is a balancing act. There are competing interests here. There is on the one hand, there is an individual's right to privacy and the right to protect their reputation against the competing right of freedom of expression which Google has to publish this material. So when you're looking to, so the arguments one needs to deploy in order to get material removed is one needs to obviously explain why the material is inaccurate. But the key issue, and this isn't flagged up properly in the form, I don't think, this is the weakness of the process, is one's got to establish or say why it is not in the public interest for that material to be published, irrespective of its accuracy.
Okay.
So that's key.
So just for our audience, many of whom are either corporate or lawyers working within corporations or communicators working within corporations, this is not a right which applies to organisations at the moment. So if there's been something inaccurate printed about our company, this doesn't apply. However, if it was something inaccurate about our chief executive, how do we stand there?
That's right. This law applies to what we call data subjects, and data subjects are in effect individuals. Now, organisations shouldn't kind of be downhearted because actually the reality of most reporting is that all stories are told through the prism of people.
Yes.
So if an organisation is being reported on, chances are the CEO or some other corporate figurehead is going to be wrapped up in that story, and so you can use them as the vehicle for getting the material removed. That's it.
Excellent, thank you. And publicity orders, Magnus?
Well, this is really interesting because this is a complete departure. Again, it stems from the 2013 Defamation Act. It's section 12 of that act, and for the first time, the courts have there is the power or the power for an individual in a libel claim to seek at the end of a libel case, at the end of a trial, whoever has been successful, they now have the ability under the Act to request from the court an order that the losing party publicises the judgment. Now, courts have always had a discretion to do whatever they want. So in a sense, the courts have always had a discretion to make these sorts of orders. It's just none of us have cottoned on to using it,
yes,
except relatively recently. There was the case where Apple was sued by Samsung at the end, midway through that case, Samsung successfully applied to the court to order Apple to publicize the result of that case. Where this has really come from, or the seeds of this, are actually from the PCC's code, because the PCC has for a long time had the process by which if somebody complains to the PCC and that complaint is upheld, the losing party, i.e. the newspaper, would have a duty to publish a summary of that adjudication. So the law is effectively mirroring that. But this has potentially huge consequences for us in terms of the proper publicising of a successful result and the vindication to a reputation that entails.
And a couple of thoughts from me. If, on the other hand, unfortunately, you're on the losing end of a publicity order and your misdemeanors have been published in the press, couple of thoughts there. The first is it's all about reputational credit in the bank. So this is where all of the positive, proactive reputation building that you will have done ahead of this negative coverage will actually pay off. I think we'd all agree that an unknown organisation with no reputation and no relationships is going to suffer far more from this piece of negative coverage than one that has built up a strong reputation and relationships beforehand. And the second thing I think I would be advocating is um, actually being proactive in communication around the legal process itself, shaping the narrative of how that particular case plays out, rather than the communicators sitting gagged behind the scenes and just letting the law happen to them. But I don't know, as a lawyer, Magnus, whether you would welcome the communicators into that process.
I would welcome them with open arms, but the key thing is not simply not just at the point of trial. Actually, proper reputation protection in this area stems by collaboration right from the very start.
Right.
And sometimes that can include being having communicators be part of the decision as to whether to sue or not.
Yeah.
And then to have a part to play in the drafting of the documents and actually to help manage every stage of the litigation process.
And this is why I like Magnus so much, because he's the kind of lawyer that likes working with the communicators rather than fights them off. So he is our favourite lawyer. Okay, now one might think that one of the other things that might have changed as a result of social media is how we apply the copyright laws. Is that a fact, Magnus?
Again, it isn't that the legal principles are there, and the legal principles haven't changed in respect of copyright. It's not even the application, in fact, but the application has remained the same. But there are a number of sort of myths that have arisen around, the use of copyright and things online, and I think it's a lot of these have arisen just through the sheer volume, and so people aren't able to. It goes back to monitoring.
Yes.
People aren't able, due to the sheer volume, to be protecting their intellectual property rights in the same way, but they really must. It's absolutely
And
crucial.
fundamentally, they have exactly the same rights over anything posted online as they do if it was printed in a conventional magazine or newspaper.
That's absolutely the case. Yep, absolutely. So, for example, and we can just trot through the bullet points that are on the screen for people, but republishing copyrighted material without a license or permission is still a breach of copyright, whether it's in hard copy or online. Copyright attaches to any original work, and really people again often underestimate quite how little one needs to do to create an original work. The defence of fair use does apply, but again, I think because often it's commercially convenient, people overestimate what is fair use and start to use too much of material and run into problems that way. Material, again, people sometimes conflate copyright and trademark, and people think, where there's a trademark symbol, right, that's trademarked. And where there's a copyright symbol, that's copyrighted. And so if there isn't a copyright symbol, that's okay to use. Copyright doesn't require any sort of recognition like that symbol. So people do it, and it's a good idea to do. But if it's not there, don't assume that you can use it. Then the issues really, the biggest issue is around republication of material. Yes. So just because the work's been posted on another website doesn't mean that if you republish it, you're not liable for a breach of copyright. You would be. And there's no defence if you're intending to use the work for commercial gain of any kind, then you're obviously in breach. And again, giving a credit to somebody doesn't get you off the breach either. That's no defence.
Okay, a quick case study which many of you will be aware of, which touches on some of these areas where lawyers and communicators maybe haven't worked totally effectively together. Many of you will be aware of Greenpeace's campaign against Nestle regarding palm oil and its effect on the orangutan population. As part of that campaign, again, many of you will be aware that Greenpeace created a spoof Kit Kat advert that ran right across YouTube, and Nestle were successful in taking legal action to have that video taken down. They were successful in their legal action. They were not successful in stopping people watching the video because, of course, it spread like Topsy via other channels. Equally, you're probably aware of the Facebook conflict which broke out as part of this campaign between the people moderating Nestle's Facebook page and activists and just general members of the public who were posting tough questions, often accompanied with a brand jacked Kit Kat logo, which had been rebranded Killer. And a big part of the response on Facebook to that brand jack logo was a threat of legal action for copyright infringement, which resulted in a major conflict on the Facebook page and criticism for Nestle trying to take comments down and stifle freedom of speech. Some observations coming out of that situation. A broader point, aggressive moderation of social media sites can actually make a challenging issue into a very high profile crisis. So moderating effectively and appropriately is crucial if you have a Facebook or other online platforms that you're operating. Secondly, to Magnus's point earlier on about working in partnership, take legal and communication advice before you decide to take action. Sometimes just because you can take legal action doesn't mean that you should. And finally, scenario planning. I'm pretty confident that Greenpeace were actually delighted that Nestle took legal action because it gave them further publicity. So engage in scenario planning when you're facing a challenging situation and work out what your adversary would most like you to do and least like you to do and the ramifications of that before going down a certain course of action. So that brings us on to another area. We've now covered about material that you post online. We're now looking at what about third-party comments about you? How can you protect your reputation from third parties saying critical, negative, false, inaccurate stuff about you? So, Magnus, you've touched on it already. Well, what are your legal actions if that happens?
There are stages, if you like,
Yeah.
or layers to it. And again, perhaps the overriding theme of today's webinar is really the importance of monitoring. We can't, you've got to follow what is out there. You've got to police it. Once you have identified a source of attack, you need to risk assess. What that attack is, and the sort of factors that one needs to be thinking about in these terms will be things that we all kind of come across. But it's how serious are the allegations? First of all, that's first and last. What is the likely audience? What is the real risk of dissemination? And what is the public's the underlying public interest in those allegations? And I think that's important to do on a case-by-case basis because in this new environment, one needs, I think, two things more than anything else. And the problem is we as lawyers often don't have them, which is a sense of humour and a sense of proportion. So choose the things that you're going to attack, and that may not be everything. There may be times when it is appropriate to attack everything or seek to get everything corrected, but that risk assessment is absolutely crucial. The first layer, if you like, so if you're dealing with offending comment, something that is up there that you don't like, the first is to, if you can, write to the offending author, and get that removed. Now, again, from a public relations perspective, it's important to be seen to be writing to the author rather than somebody else. If you have to write to, the ISP or the blog or the platform, so be it. But in the first instance, I think it always looks more attractive to have been seen to be writing to seeking to get it removed from the author themselves. The second point, so if that doesn't work, you're then looking to see whether the platform itself, under its own terms and conditions, would have that removed because it's offensive, inaccurate. If you look at Facebook or Twitter, the terms and conditions are fairly generic in this area. The action of last resort is to threaten to sue in libel, and if they're still not paying attention and still haven't got it removed, then depending on the risk assessment and the seriousness of the allegations, if you need to sue, then do so, subject to the form the potential for successful defences, obviously. But again, the importance here is about acting as fast as you possibly can. Speed of response is crucial because you're cutting down the risk of dissemination. You're cutting down on the risk of it getting to search engines and other jurisdictions and being more difficult to remove that way.
Okay, thank you. And how about third-party comments specifically on our own platforms? Many of the people on this webinar will have Facebook pages for their organisations or a blog maybe by the CEO. How should we go about protecting ourselves with regard to those?
Well, the key here is again, moderating is absolutely key. And there's an interesting sort of legal and commercial loophole here, which is where the courts have taken the view that in a sense, the less a website is moderated, the less responsibility the owner of that website has for what is on there. So, in a sense, we've created an environment where it's both legally and commercially sensible not to moderate, not to take responsibility, which is crazy. But where we're talking about one's own, so an organisation's website or Facebook page or whatever it might be, the crucial thing to remember here is that if somebody publishes something on that site that is defamatory, they will be responsible for that publication, but so will you, because you're the one who's providing the platform for that defamatory allegation. So it's absolutely crucial, so as not to expose yourself to liability to be moderating content all the time. Now, we then come to so if one's going to moderate, one needs to be seen to be moderating in an appropriate way and in a consistent way. That's absolutely crucial, because the number of people who will respond and say, well, you've removed what I've just said, but why didn't you remove the criticism from 2 weeks ago or whatever? And then the real judgment call, again, which is probably a PR judgment call rather than a legal one, is do you give reasons or not? Now, as a lawyer, you'd expect me to welcome a vacuum. So in some ways, I think often you raise more questions than answers if you give explanation. But let me say from the outset, from a legal perspective, there's no duty to provide any kind of explanation.
Okay, so clearly what we're talking about here, when we're thinking about our own Facebook page or, say, blog, and certainly as in the Nestle example, we're talking about criticism from third parties on our own platforms, and few thoughts from our side as to how we deal with that, because I think in many ways a lot of this online criticism that organisations receive, we would have to admit, is, if not fair, entirely predictable. And so from a communications perspective, here are some of the things that we think organisations should be thinking about to prepare for attacks of that kind. Reputational risk audit, with the lawyers and the communicators, again, working together to identify where are these threats coming from, what are the likely areas of vulnerability that we will be attacked on over the forthcoming period. Stakeholder mapping, analyse who is likely to come at us and how influential are they, and who can we identify as those independent, credible third parties who can speak on our behalf to defend us from some of those inaccurate or unfair claims. Scenario planning, again, to work through how these situations might play out and then critically how we would respond to them. And as I'm sure all the communicators on the call will recognise, really there are then three options if we've identified these areas of vulnerability because of our activities. Either change what we do so that people can no longer criticise us for a particular activity, change how people perceive us via good, effective, proactive, positive reputation management, or continue to accept that risk but put contingency planning in place to deal with the issues as and when they arise. And that's the escalation process for managing an issue or a crisis, getting the people identified, trained, and going through exercises so that they are ready and able to respond should the worst occur. Okay, so let's move off what other people say about us to what we say about ourselves. Firstly, those, let's call them official online content that we put on our own Facebook page or blog or website. What are some of the key things that people should think about when communicating on behalf of their organisation, Magnus?
Well, some of these are going to sound like stating the obvious, but the number of times that these are where mistakes arise means it's worth repeating. Put simply, that the golden rule has to be: do not publish anything that you cannot verify as true. That's really the gold standard of by which you measure anything that you're publishing. The second thing to remember is that every republication of something that might be defamatory gives rise to a fresh cause of action, to fresh liability. So there is no safety in publishing something that somebody else has published. There's no defense to that. Thirdly, don't try and it's what I would call the Ian Hislop defense. So don't think that you're safe in defaming somebody just if you stick allegedly in front of it. It doesn't work. And then finally, any statement that if you do want to comment on things that are, and often this is a very good way of generating publications and generating buzz, is to be a commentator on a particular issue or piece of news. Make sure that it is clearly flagged up as comment, that it isn't put as an assertion of fact in some way. And if it is a comment, make sure that it's objectively fair and that it's in the public interest.
Great. Now, as a communicator, I just wanted to put in a word for the effective use of social media in sensitive situations. And this isn't just because I know we have guests from TSB on this webinar, but I do think the example from a couple of months back when Paul Pester, CEO of TSB, responded directly to customers who were having problems following a service outage is a great example of where, you know, a human voice, a human tone of voice, and maybe a response that could have opened the organisation up to some legal liability, maybe by admitting fault, but actually the feedback and the benefit of putting that human voice forward far outweighs any potential legal risk. And so Paul Pester was tweeting, for example, "My apologies to TSB customers having problems with their cards. I'm working with my team now to try to fix the problems," with his initials at the end of that tweet to signify that was coming from him. And then a further interaction with a customer. And I think what's interesting is that in addition to customers themselves providing positive feedback to Paul Pester for his words, the media were also making his role in that situation a positive part of the story. So Joe Lynham, for example, from the BBC, tweeted, "Impressed to see TSB boss Paul Pester responding personally to customers angry at IT glitch." So make yourselves as legally safe as possible, but don't allow that to prevent you from communicating in a human, appropriate way, even when the stakes are high. In fact, that's the time when a human personal touch can actually work very effectively for you. And the final area really to consider is that which isn't official comment from the organisation online. And we've seen a number of examples where organisations like Chrysler, Vodafone, even the BBC recently have had employees posting comments or thoughts online which have been, let's say, unhelpful to the organisation. And I think both Magnus and I would say that the first step in starting to address that issue is having a social media policy. And Magnus, from your point of view, what are some of the critical elements to have within that social media policy?
Well, there's no particular magic to the content of those policies. Actually, where most people come unstuck is in the application of those policies. So, number one, you can have the best worded policy in the world, but if it's gathering dust on top of a cupboard, it's no use and it's not practically enforceable. And wouldn't provide you with any defence further down the line come an employment tribunal. So the first thing is, if you've got such a policy, and everybody should, is that it is properly trickled down to every single individual in the organisation, and that you have procedures in place that you can monitor. People have read it, acknowledged it, and probably best of all on a fairly regular basis. So via sort of email updates on a perhaps 6-monthly basis, that sort of thing. Mm-hmm. The second thing is people. The other way in which these things are let down is when they don't have sufficient guidance for people to actually be able to rely on. And again, we've got some bullet points about what would amount to unacceptable content. Fairly obvious. But in fact, it sort of brings everything that we've been talking about together. But actually, what I'd like to finish on in respect of this point is a rather grey area, which is that social media policies will apply to employees during the course of their employment. Now, that sounds obvious. It sounds perfectly reasonable, but the difficulty comes in defining properly what amounts to course of employment. Now, for some people who are kind of clocking on at 9 and leaving at 5, that will be obvious. But as you go sort of higher up a company, the boundaries become less and less defined. And actually, when you're at the top of a company, very senior employees will in effect be acting in the course of their employment doing all sorts of things. If they're out at a marketing event, for example, and they tweet something or they say something to somebody, there's a very strong argument that if they publish something defamatory, that they were actually doing that in the course of their employment.
Yes.
So again, the problems are practical ones of application rather than anything else.
And I just wanted to endorse something that Magnus said earlier on that slide. It really isn't enough just to have a social media policy. It is about bringing that policy to life, making people aware of it, and also giving them the chance to interact with it. So if it's going to work, it needs to be much more than the stereotypical policy, dusty old policy on a shelf. So taking people through exercises, simulations where they get a chance to deal with social media, maybe as part of their induction process, I think helps to make that what could be dusty policy real, and to help people to understand what it means in practice. So the final area that we're going to look at is legal and communication teamwork, working in perfect harmony as these two gentlemen always do. Some thoughts from me as to how these two, certainly in my view, critical areas of expertise can work together effectively to protect reputation, particularly with regard to this social media context. I think the first thing is for us all to recognise that whilst we bring different expertise, we have the same objective, which is to protect the organisation, to protect the organisation's reputation and business. And I think sometimes there's almost competitiveness with, but ultimately the bottom line is we're all here for the same reason. I would always advocate yes, the lawyers and the communicators working together collaboratively. Both parties need to give their best advice, and then I think ultimately, if it's a tight call, it will be down to the CEO or the ultimate decision maker to decide which way they go. It's our duty to give best advice. It's their responsibility ultimately to decide. And I think we can observe on a general basis there are some organisations where the CEO is more minded to take the legal advice. Some organisations, they're more minded to take the communication advice, but it's important they hear both. Critically, and I think we've touched on this on more than one occasion, it will work best if there is genuine mutual trust and respect between the lawyers and the communicators. And that clearly needs to be based on a pre-existing relationship. If you're meeting your peer for the first time when you're under enormous pressure and something awful has happened, that is not the best time to be building a relationship. And I would suggest that involving the lawyers and the communicators together in the planning process, whether that be the reputational risk assessment we talked about, working through some of the scenarios that we discussed, and both participating in the crisis simulation exercises. Those are all great ways of building that relationship and that trust between the two parties. And final bullet point, which is a specific but very important point, have those approval procedures agreed ahead of time, not suddenly finding out that we have slightly different views on what the process is and how quickly it needs to take place in the heat of a crisis. So, work that out beforehand rather than during the crisis. Anything you'd add or disagree with, Magnus?
I certainly wouldn't disagree with any of that. I think it's more an issue of emphasis. I think the proper crisis management ultimately comes down to anticipation.
Yeah.
And anticipation requires both skill sets.
Yeah.
And it requires both skill sets to be working together from, as far back as possible. And in doing that, what I think happens when it's most constructive is both sides get to see the other side's skill sets.
Yes.
And so everyone becomes more confident about working with each other. They become less defensive about what about what it is that they can't do. And I think lawyers often, because this is what clients require from us, is to think in fairly, or to present in fairly black and white terms.
Yeah.
This is wrong or this is right. This is what you can do and this is what you can't do. And I think public relations advisors work in the grey area in between. And so we need each other at the end of the day.
I thought you were going to say PR people work in the twilight zone or in the shadows. But, okay, a summary slide. This chart, which I recognise you won't be able to read too effectively on your screen, but is in the report that you'll be able to access after this webinar, just really summarises some of the key ways of protecting your reputation from a social media crisis. Predict and plan, as Magnus was talking, the anticipation phase, the risk assessment, the scenario planning, the developing that approval process. Preventing own goals. The worst crises are those that are self-inflicted. So having and embedding that social media policy, for example. Relate and rehearse what we've just been talking about. Get that legal and communication relationship working well. Run social media simulations so that we test and train together and are singing from the same hymn sheet. Monitor and respond. We've heard that theme of monitoring throughout. Know what's being said about you and then take a proportionate response to it, whether it be from a communication or from a legal point of view. And then, having been through the heat of a situation, review what worked well, what didn't work well, what do we need to improve on, how can we further protect our reputation in future. Now we're entering the last couple of minutes of the webinar, and with that in mind, I'm going to ask if there are any questions, maybe if they could be directed to us after the webinar, because I'd just like to summarise what next, really. Firstly, Magnus, thank you very much for sharing your insight and expertise. We do have a more detailed report on the back of this webinar, which we will be emailing you a link to following this session. You can also download it from our website, but it will be available. It includes everything you've heard from Magnus this afternoon and more. These slides and the audio of the webinar will be available from next week, and again, we'll send you a link to that. Please do send us any additional questions or comments. We will promise to deal with anything that you, well, I say deal with, we will answer any question that you send to us subsequent to this session. And we'd be happy to help with if you're actually facing any of the issues you've heard about on this webinar. Final thing to say is, firstly, thank you for joining us. And secondly, to let you know that our next webinar will be taking place in September. That again is focused on social media and reputation management, but on that occasion, taking a look at how social media has changed the way that reporters break and cover news stories these days, in particular crisis stories affecting organisations like our own. So thank you again. I hope you've enjoyed and found the session valuable, and we'll be sending you further information subsequent to the webinar. Thank you.